New York State penal law provides that a person is guilty of resisting arrest when he intentionally attempts to prevent a police officer from effecting an authorized arrest of himself or another person. It has long been recognized that an authorized arrest is an arrest made pursuant to probable cause that the law had been violated by the subject of the arrest. Probable cause is established by the conduct of the subject defendant and not the conduct of the police officers. If a subject has the right to flee from a police officer, a subsequent police officer does not have probable cause to arrest that same subject merely because he sees the subject running from a police officer. He may have the right to stop and inquire. He may even leave or have a basis to detain the subject by force. But breaking free from the grasp of one police officer does not establish probable cause for another police officer to make an arrest. In the case at bar, Officer Dooley did not have probable cause to arrest the defendant for possession of an alcoholic container in a public place. While it appears that he did lose sight of the defendant during the chase and that the defendant did come into contact with other police officers, Officer Dooley did not provide any other basis for the arrest other than the open alcoholic container. Other officers testified at this hearing, so there is no evidentiary basis to determine whether any of the other officers had any legal cause to arrest or apprehend the defendant. The Court of Appeals held that the police do have a right to inquire of a subject so long as they have an articulable reason for doing so. The police can physically stop and detain a subject so long as they have a reasonable suspicion that the subject was involved in a felony or misdemeanor. They may not arrest the subject, however, unless they have probable cause that an offense has been committed. See also People v. Holman, 79, New York 2nd, 181. 581, New York Supplement 2nd, 619. 590, New York Supplement 2nd, 204, 1992. In the case at bar, the defendant was thought by Officer Dooley to only have been guilty of a violation of a local municipal law, which was neither a felony nor a misdemeanor. Furthermore, there was a probable cause to arrest the defendant for drinking in a public place. While there may have been grounds to stop and detain the defendant, the people failed to establish that the arrest of the defendant was authorized. There is therefore no probable cause to arrest the defendant for resisting arrest. Accordingly, all statements made to the police subsequent to his arrest are suppressed. Furthermore, the statute providing a civil remedy for damages proximately caused by a failure to report suspected child abuse does not impose liability for harm suffered by individuals other than the subject child or abrogate the common law rules limiting the scope of liability for purely emotional or psychological harm. McKinney's Social Services Law, Section 420, Section 2. The overriding concern of the legislature in creating a civil right of action for failing to report suspected child abuse was for the protection of the abused child and the provision of appropriate service to identified perpetrators with the aim of preventing further harm to children. McKinney's Social Services Law, Section 420, Subdivision 2.
It's okay.
You want to read it?